We have screens. So we got the first thing conquered for the day. For those of you who don't know me, I'm Angela Ehlers. I'm the Executive Director for the Association of Conservation Districts in South Dakota. And this is, he's got a fancy new title.
Fancy new title, Anthony. Bill Smith, South Dakota Department of Ag and Natural Resources. I'm the Division Director for the Division of Resource Conservation and Forestry.
And we have put together a PowerPoint for you. This is one of the goals of the association is to help producers, local governments, our partner agencies understand better the sediment erosion control laws in South Dakota. These were adopted a long time ago, like in the 1970s. God, that doesn't seem that long ago. But we are seeing more and more potential issues with erosion control, and especially as we're moving back and forth out of droughts and we're seeing climate change. So we would just like to help you better understand what the law says, what your responsibilities are, what your partners' opportunities are. And we plan to we have a slideshow that we'll go through with you. Some of the employees saw it at the Employees Association meeting in June? Okay, June. But a lot of supervisors haven't seen it. And what really brought this about is we had a couple cases in south central South Dakota in which a producer was burying the gravestones in a cemetery that was neighboring a field.
You want to tell us district?
No.
Okay.
Do you?
No.
I just said south central South Dakota. That's a pretty broad part of the state, right? But anyway, the guy even had people buried in the cemetery, but he was burying the gravestones now. So that was causing a lot of emotional upset, and it took us about 5 years to finally resolve the whole issue. We also had a producer that, we had another issue come about in somewhere closer to here, in which the producer was filling the road ditches with dirt, and it was mostly through sediment.
And some of the culverts.
And some of the culverts. Anybody here besides Mr. Barth, the county commissioner? Got an idea how much a culvert costs?
It's all highway department.
Anybody here with the highway departments?
Well,
DOT's
yeah,
downstairs.
we're in
I didn't
there
notice
too, leaving
that.
the building.
I can tell you that I'm on a city council, actually no, I'm the mayor, but we were having to replace some culverts this spring, or coming spring, and we were pricing them out, and they have tripled in prices this summer. So we're going to pay a lot more for a 14-inch culvert than we did. But erosion is an issue to counties and townships because of the possibilities of damaging the roads, and we'll talk about that too. So those two, each time Bill and I get the phone calls, okay, what do? We got a complaint. So rather than keep individually treating you, we thought maybe it'd be better if we would try to get around the state, work with you all, get you to understand the basic familiarity with the law, what your options are. And we're always there for individual assistance, but it's a lot easier for us to meet with multiple districts than to meet with each of you 69 times.
And the important thing to note on this too, the law's been around for a while. It also, a lot of, we do get questions occasionally, what's the difference between this and HEL compliance, and we'll get into that a little bit as we get into the presentation, so we want to put that teaser out there. It is, and we've had instances before where it's involved non-HEL land, erosion's involved non-HEL land, and there's been discussion, well, it's not a violation of HEL compliance, so there's not a problem. Well, that's false.
And let's make sure everybody knows what HEL is. Highly erodible land provisions of the Farm Bill. Okay. Again, the issue we're going to talk about is excessive erosion. And please, if you have a question, thought, comment pertaining to this issue, sometimes we get stray thoughts, I know that, stop us. It's really good if we can all discuss the issues as they come up and we don't have to backtrack.
And also too, there's gonna be questions, you're gonna look at some of these handouts, think about what was said today, maybe even talk to some of your neighbors, you might have some questions, and that's where we can do some follow-up discussions,
Yep.
and we deal with a lot of, sometimes what ifs,
Yep.
and what about this situation, and, this isn't gonna be a one and done discussion, this is kind of the start of it, and hopefully, when things start to happen, hopefully they don't, but if and when they do, and we know they will, this will at least give you a resource on starting to think about things and formulating questions, and then at least knowing where to go to discuss those, so.
And I wasn't polite, I forgot to put down our meeting room basics. You know where the restrooms are, feel free to go to them when you need to, just don't interrupt the meeting. And we need to introduce each other. But I do want to ask you one question. How many of you are concerned that you could have an erosion control issue in your county within the next year? First topic, again, we talked about the difference between federal and state law. But the issue, of course, is excessive erosion. And well, we want to make sure, first of all, what is the difference between the state law, which was passed in the 1972, I believe, and the United States law, which was 1985. Under the state law, it's called the Sediment and Erosion Control Law, and that's what we're really going to concentrate on today. And it's the responsibility in the law specifically for conservation districts to carry it out and regulate, well, a little bit of regulation, but enforce. The erosion control standard in that is 1T. And this is where we're going to get into the conversation of T as it's defined today, because one of the conversations we've also had is T, the proper way to measure erosion. And we're going to, that conversation I think is going to continue, but at the time in the 1970s, that's what we talked about. T was the amount of soil. I know there's a DC or two here that's going to tell me I'm wrong. It's the amount of soil you can lose in a year and still be replaceable. Sound pretty close? Yes, no? Nobody's telling me I'm wrong. Most of the soils in South Dakota are 5 tons, which is 1T. Or like around the wetland areas and some of the more sensitive areas, they can go down to 2 and 1. That sound right for your region? I am much more familiar with the center part of the state. Okay, Jim's shaking his head yes, so I know I'm right. Okay, our enforcement ability under it is court-ordered injunctions. And we also, your producers can also be barred from receiving state conservation benefits. Okay? Then we have the United States law. Again, this was passed in 1985 as part of the FSA, Food and Security Act at that time. I was around, believe it or not. And it is the responsibility of the U.S. Department of Agriculture. The standard there is 2T. Notice it's different than the state standard. So you can be out of compliance on the state level and still be in compliance on the Farm Bill level. Make sense? And then enforcement ability is loss of program benefits, which is your cost share programs, your commodity program payments, etc. Okay?
And the one other thing to note too is an action in one doesn't automatically trigger an action in two.
Right.
So you can be out of compliance in both, but they both require separate processes and separate actions.
Go ahead.
Just with that last comment in mind, I'm just thinking, hearing it, going, somebody saying, well, the DC doesn't care, or the DC has said this isn't a problem.
And we have to make sure they understand.
And that's great, but that, like you said, that's not the state issue. That's, you're not in trouble with the feds. It doesn't mean you can't be in trouble.
Which is one of the reasons we invite USDA to these meetings too, so everybody understands. We've got 2 separate laws, 2 separate rules, but both of them are coming. It doesn't matter whether you're a conservation district supervisor or an NRCS person. If they want to come in the office and complain, are they going to ask which one you are to complain? No. So it's important we all understand these are the rules. Okay? The other thing, well, we're always, remember, this was the issue. This is where we're trying to get to. Tolerable erosion. Actually, almost any erosion could be intolerable, but we want to get down to tolerable erosion. And this is an important one. You want to mention that one then?
Yeah. Regardless of the action at hand, if somebody is being damaged, there's always the civil option. You know, again, and that's a different process altogether, but that's a process directly between 2 parties. if I'm being damaged, I have to bring the action against Angela. Charlie can't bring the action against Angela if I'm the one being damaged, so.
The cemetery association actually got to the point of threatening to sue the landowner and the producer on the damage to the cemetery. That's how far we got down that road before they actually start paying attention.
And it's also possible where you might be in compliance with both of these, but you're still being damaged. And I'll give you a good example and point. We don't really talk about what happens with residue.
Right.
But these don't cover residue moving off site and causing damage. So if my cornfield is, I farming away my cornfield, all my corn stalks are washing down and plugging up the culvert in front of Charlie's and it's causing damage.
Sorry, you're sitting in the front row, Charlie.
Yeah, I'm looking right at Charlie, but it's causing damage to Charlie. That would be a civil action that Charlie would need to bring on me because it's not really covered in this area.
Right, because this talks soil loss,
Yeah.
not residue loss. But you're right, there's always reasons to go to court if you want to. So, any questions on this? Make sense?
On the state law, is it water and wind?
Yes.
Together? It is, okay.
And there's different remedies for both that we'll cover.
Yep.
So, but the water and wind still follows what our PD will say?
At the moment, yes.
Okay.
And that's why we're having conversation about is T accurate for all of it? Because there's been conversations on the national level on that too, even within NRCS, is T what we need to be farming to? So, anyway, shall we move forward? Okay.
And the excerpts you see, the handouts you see before you here, with the exception of the law, is in the supervisor handbook, which is online. The association, our office, and then a work group of the association revised the handbook back in 2017, and the commission signed off on it in early 2018, but it's up on the website. If you have any issues finding it, let me know.
Department of Ag and Natural Resources website.
Yep.
And they have it all as a PDF yet?
It's a PDF. We have two ways. We have
Are
a
the forms
PDF
enough?
for the entire document, and then we also have where you can go just to that specific section in PDF and pull that out.
Okay, if you
These
need those forms,
forms are in Word.
okay,
The only thing that's not is the statutes, which are before you here. The reason we did not put those in there, statutes can potentially change. And we'll talk about one change that happened 2 sessions ago, which if we'd have put it in the handbook is out of date, but
Right.
the state laws can be found on the LRC website, South Dakota Legislative Research Council's website.
sdlegislature.gov.
Yeah, and.
Or you can call me, I can find it for you.
Yeah, and the nicest thing is you click right to the section of the question, so. Great.
And you all know how to find Bill and me, right? I'm pretty sure you do. Okay, again, all the laws at sdlegislature.gov, these are the laws we're going to talk about. We have the original law, which is the Sediment and Erosion Control Act. In the 90s, they included the Blowing Dust Act, which has got a whole new set of process to it. And then you can actually blame me and the county highway superintendent in Lyman County for the county highway erosion damage and the township highway erosion damage. Those two we'll talk about, but those were passed in the mid-90s, and they were to allow counties and townships to recover damages for damages to their roads. And we'll have further discussion on those.
And the reason state highways aren't mentioned, there's already a remedy in place for the state DOT to recover for damages.
Yep.
So
Okay.
we weren't trying to omit them, and same thing with the federal law, so.
Okay, we created some flow charts because the law itself bounces like a ping pong ball. And so we created some spreadsheets for you to look at, and we handed them out. We're going to run through them. The easiest way to do that was just do a flow chart so that you see how the process works. Okay, and the first one, of course, was by 1977, all of the conservation districts needed to adopt standards. And that basically is what you all did. You had public hearings. I know most of you weren't around in 1977. I wasn't at the conservation districts in 1977. But they used the public hearing process, the regular one. You published a notice, you had hearings, and then you had to go back and vote whether or not to adopt the standards. Most of the standards are to the T level, and it identifies all the soils within them in a table, saying this is the level of T that's allowed for that type of soil. Okay? Then, Go
one
ahead.
thing before we go on to the next bullet, you know, as Angela mentioned, all districts had to pass standards, and we'll talk about the process for how they pass them. But one of the things we've noticed is a lot of districts really have not reviewed those standards in a while. I know there are some exceptions to that, but one of the things we'd encourage you to do is to take a look in your office and see if you can find those standards. And because there's a lot of new people then out there, take a look at the last time those were updated. Those really should be updated, and there's a process for that we'll cover later. But every time there's a new soil survey that comes out.
Or any change to your soils. I know the soil survey is done on the web now, so there could be changes within that. But if you've taken a complex soil and split it out, and it now has different Ts, and your standards aren't updated to reflect that, you really don't have the basis to do the Erosion Control Act. So, the standards were developed, and they had to have the hearings, which is all this says. We've already done all this, so we can go on to the next slide. But you're gonna, and then the State Conservation Commission, of course, had to review those standards, so they did. And then after they're all adopted, then we also worked with units of government to let them know that they've been adopted. And this is done again in the 70s. So most of you haven't got any experience with this, but they met with their counties. They met with their planning boards, they met with the cities to explain to them that they had standards.
And the local units of government are key in there too to know, because this does not just cover ag land, this is
Nope.
any land disturbing activity.
Yep.
Good case in point, if you've got somebody who's developing some land, I remember when one of my neighbors was digging up his, he was putting a lot of dirt on my neighbor's place and my place, and we didn't file a formal complaint against him, but we did talk with the city of Pierre and with the landowner, and he had to adopt some remediation strategies to keep us from having, you know, my kid's swing set under a 1/4 inch of dust every time he went out there, having to water the lawn and mow the lawn.
Well, for a while, I guess it isn't effective anymore, but Hughes County County Commissioners and the city of Pierre, all of their developments were reviewed by the Conservation District to make sure that as they were developing those areas, they were staying within the standards, so they didn't have the erosion control issues. Okay, now we're going to revise them, and we did make some changes to this law a couple years ago, thanks to Coddington Conservation District, because there was originally, okay, well, one of them did this one. I can't remember, we did this one. Anyway, right now, then it says, used to say that if you wanted to revise your standards, you had to have 10% of the qualified voters in the district sign a petition. This gets a little crazy when we get into Minnehaha County, because you know how many 10% of your qualified voters is? It's like 10,000 people to sign just to revise the T standards. Yeah. And that's where we noticed that this was an issue. So we have a change in the law that says it can now be done by a majority vote of the Board of Supervisors. And basically, that's just to make sure that we have a way to easily update the standards if you're making a minor change like identifying a soil that's got a new T.
And the hearing requirement's still in there from
Hearing
what it was
requirement's still there.
before. So when there was a change, the public would be notified.
Yep.
And note that the hearing requirement's a little more depth than just posting your agenda like you do for your annual
Right.
board meetings. And that's to make sure that any people who are interested have the opportunity to know, A, it's being changed, and B, where to come hear their voices on that.
And I would point out, you don't just have an annual board meeting. You guys should be meeting more than once a year. You are, I know you are. If you do not approve of the revision, then there is an election held, and it's a special election run through.
If it's a petition.
If it's a petition, then that all has to be done within 60 days or within 3 months of the general election. If you approve the proposed revision, yeah, my battery on that thing's stuck, so keep it plugged in. Approves the, there's no deadline. There's no election if the board says, yep, it's a good change. Okay? So this is why we encourage you, go back to your sediment control standards. How many of you know where yours are? 4. He says yes. What do you say? Okay. But take a look at them, because the soil surveys have been updated. And make sure they're up to date, because if you get a complaint and they're not up to date, you're going to be in a little bit of trouble trying to figure things out.
And we did have one district who wanted to do an enforcement action, but they couldn't find their standards.
And we thought they were on file with the state, but the state's
Well,
record-keeping records from the 70s are maybe not the greatest in the world either.
we have about a third of them that we can put hands on.
Yeah.
But the other catch was, we did have some districts who did never send them to us either.
Right.
And there was no provision in state law to basically
archive them.
penalize if they didn't send them to you.
Right. So, please, go back, take a look, make sure you have them, make sure they're updated. They're gonna be necessary. Okay. This is enforcement. This is the fun job. How many of you guys like to enforce your laws?
I have a
Tammy.
question. When you get back to that, is there a plan or a set thing to use to go by?
There is a template out there.
Are your standards? Yeah.
Ours wasn't been updated since '07.
Well, yours is,
Well, compared to some, we just done this in the century.
But I just didn't know if there's a template, because I'm not really for sure
Yeah.
if ours was.
There is a template out there.
and if you can put your hands on your old one,
On the
that's
website.
following the template, but, so.
Yeah.
In kind of response to Tammy's question, and Bill, and it's the, varsity. How many of the 66, 69?
69.
69
Maybe
plans?
68 in a year.
All right. How many of the 60-some plans are current? Do you have a feel for, again, as Joan alluded to, hers still says 1977 on it.
I guess less than 10% are.
Well, I can say at least what the commission's acted upon in the last 5 years, which I consider current, there's been about 4 of them. The rest of them haven't been touched since then.
It's pretty overwhelming when you look at it. It is. And
Well,
when we did update it, it took us forever, and we went to county commissioners, and then wait, it was quite a.
But if all you're doing is updating the soils table, it isn't so bad. And that'd be the first step I encourage you all to do, is make sure your soils are up to date.
And then the other thing is if you can't find them, then you probably really should rebuild them.
Yep, you're gonna need them.
Is there a template for that?
Yes,
I think it's on your website.
yeah. Although with the website migration, I'm not exactly sure where it is, but we'll have to take a look for that, look for it, Fred.
Call Bill.
Yeah.
And to update the soils table, is that an easy project, or how do you do that? How do you go about?
Within your standards is your current table. Go back to your web soil survey and look at all your soils that are now listed. Because Darren, you guess most every county in the state has had changes in their soil tables.
They have, yeah.
And it's been within probably the last 6 to 10 years, if I recall.
Yes.
Yeah.
So go back to your soils tables, ask the assistance of the state soil, or the soil scientist if you need to, or your DC. Get those tables to match.
And that's probably the biggest thing we've seen on some of these older ones, is the tables are out of date, and it wouldn't be a super heavy lift to get them up to date. It's just, it's kind of like painting the fence, you just have to put the time in it.
Maybe it's something we can add to our employee agenda for next year, that we do a seminar on this and do a little PowerPoint showing the employees how to do this.
Right, because I'll give you the same point as we've had discussions in the ag property value tax evaluation task force that I participate in. And counties and cities rely heavily on the soils to figure out how to value ag property. In the 70s or the 60s, they didn't have the equipment they have now to make a fine tuning of the soils. We ended up with a lot of complexes where they said, well, I think it was 1 to 80,000, I think was what the scale of that was. But you'd have a complex that would be bits and pieces of various soils, but they couldn't pick them apart. You remember that, right, Brian? Well, the soils has become much more technologically advanced since then, and they've been able to pick apart those complexes. And so I think they're down to what, 1 to 24,000, I think is the scale they're at now. It's much more detailed. So what they did in the 70s wasn't wrong, it's what they had the tools to do. But the tools had advanced the science enough That's why you need to update your tables. Because that same science is what you're going to use when you start talking about the conservation plan for someone that is in violation of the standards. Make sense? Okay. Okay, now we're into enforcement. And the law says, these are all things that the law says that must be done. Like land disturbing activities on public lands are governed by this. If they're even done by the state and local governments, they must meet your sediment erosion control standards. Land disturbing activities by contract. So like if a county or a city's out there working on a highway, they could be creating a sediment erosion control problem. Well, that's subject to enforcement action too. Even permitting issuing authorities like the gentleman said here on the planning and zoning board for Minnehaha County or the city of Sioux Falls? Minnehaha County. They need to make sure that as they're doing that planning, that they're in compliance with the conservation standards. The last one, fragile land, that was done in the late 80s, early 90s when we were seeing the shale hills just over West River get broken, sod busting like crazy. Remember when yeah, I say remember when most of you probably don't. We had a Secretary of Agriculture that wanted to farm fence row to fence row, Mr. Secretary Butts, and he was thinking that all those prairie dog towns should be broken up for cropland. What a wise man. Anyway, so you could require a conservation plan before that land was broken. And that was even before we started the Farm Security Act where we got into sod busting. You go this time.
Anyway, yeah, this stuff's in the flow charts, but this talks about the process for filing a complaint. And there are also some example forms in there too. But first and foremost, the complaint may be filed with the Conservation District or the permit issuing agency. For instance, City of Pierre, you had an instance like we did. You could either have gone to the Conservation District or the city.
Planning.
Yeah, that had jurisdiction.
Right.
And again, that form is found right here. And one thing you'll note on the form, it's the top one on there. It doesn't require a signed complaint. You can be anonymous, but you can sign it if you want. But and then following that,
I want to make one point to that too. Can a conservation district file a complaint on their own? Yes, they may.
anybody can.
Anybody can, the board can. I have filed a complaint against someone. I did. We had a gentleman that had put his land into CRP and it was blowing so bad you couldn't hardly see across the road. And I thought, oh, Pucky, you're getting a nice payment here and we're creating a big, I did not make a good, he did not like me for a while. But still, it was a principle thing. I was on the conservation board and that was happening and I went, no, I'm going to file a complaint. So anybody can file a complaint. Used to be you had to sign them and people would know who the complainant was.
That'd be notarized.
And they'd be notarized, but they don't anymore. It can be an anonymous complaint, it can be a verbal complaint. It's nice to have a written complaint so that you can identify the land that is being affected.
Well, and the other nice thing about a written complaint, it's easier to show a date on there, and those dates become important because there are deadlines on these. You know, for instance, from the time the district gets a complaint to when they have to do the investigation is 2 months.
Yep, from the date the receipt of the complaint comes in. Okay, what do you do to investigate a complaint? What are you gonna do? Say someone we picked on Turner County enough, let's pick on Joan and Brookings. Say someone comes into the Brookings County office and they're just head up because they could be. That's so-and-so, so-and-so, so-and-so is causing my wet water to run across my field and has filled my gutter that I put there and my lawn is under dirt. Filled in the stock dam. Joan takes the complaint. Now what happens? Go ahead, answer. What would you next say, Joan?
Well, we take the complaint and then I let the board know about it, obviously.
As soon as possible.
Yep, we visit with NRCS and invite them to go out. We do an on-site investigation. We then write up findings from that investigation.
Good, she knows what she's
And we
doing.
send that letter to the complainant
Yeah.
and the person being on. And, you know, we've had several of them, and a lot of them were when Ryan was DC in the office there, so.
Ah, so Ryan's an expert.
But we've never, anything we've found, only one of them actually, like, literally had to, like,
Foursome?
with force, well, and actually not really, it took a while because, the guy that was, soil was eroding from on his field, he passed away, so then the land went into probate, and so we really couldn't do anything.
Yeah.
But that issue got all resolved. So we've never had to go any further, because most of the complaints we've had, we've gone out there and they've been, not substantial, you know, and a lot of them can be just a neighbor, like a half-filled McCoy. You know, like the one we had, where the stock dam was being filled in, we were out on that one too.
He's smiling, by the way, for
Well,
those who can't
it's
see
kind of a
him.
chronic complainer anyway, but, I mean, we did like 2 site visits out there, took a lot of pictures, and there is no way that the sediment from the field he's claimed it was coming from, because there was so much grass and miles before it even got to the stock dam. So, like I said, it's just like, you know, and then it just kind of stops.
Okay, Joe hit a lot of the big points. Notify the board right away, make arrangements for the board, and invite NRCS as your technical people to go out on a field visit,
And
document.
anyone else they see necessary to do that.
to do it.
There are instances where there may be some, I'm looking at Tanya, like a federal easement involved. You'd want to invite.
Or you want a drone
Or you
involved?
want a drone. Drones are very helpful, but that comes into the next point. Document. Document, document, document. Take pictures. Get the calculations figured out. Keep copies of those. Get a drone is a really good thing to do, because if you get up high enough, remember you can't infringe on the proper, you know, you gotta have permission to be on the property you're on, and but you can look over the fence line. You can't maybe cross over, right?
Yeah, you can need permission to fly over private property.
Yep, but if you're on this permission, you can take a good big view, and that's helpful. When we did the one with the water erosion and filling the culverts, they had invited the county superintendent, the township superintendents out to take a look and figure out what their damage had been. I mean, that one was pretty egregious. But get a lot of, document the heck out of them, because if this doesn't get resolved easily, and you do end up taking this to court to get an injunction, what's the judge gonna want? He's gonna want documentation, so get it from the beginning. And again, make sure that we are NRCS people. We can help you figure out the soil loss equations. And if you need, the DCs can go to resource conservationists like Ryan and ask for assistance, right, Ryan?
Yep.
That's what they're there for, is to help you. If you have, like you said, a federal or a state agency involved in it somehow, or your county superintendent, or get them involved from the beginning so they know what's happening.
So
Okay?
when you're doing a field check, then what are you checking? Are you checking the person that did it or the person that's complaining? I mean, you said you can't go over with the drone.
You can go up, and from here, look that way.
What about when you're on the ground and you're bringing NRCS with you? You don't have permission to go on the piece of ground that's causing a problem, do you?
We ask.
You just ask.
You can ask for,
So
they may get it.
they're aware that someone is complaining that they are causing an erosion.
So what if they say no?
They have to go through that.
And in those instances, you do what you can remotely without trespass.
Right.
And a lot of instances, visually, the DC can tell you what, so based on just looking at it, what the tolerable soil loss is. I can think about that one we were at out west. They were able to run the numbers and look to see what was happening to determine that the soil standards were not being violated.
Well, the other point is, within NRCS, they can also have access to cropping records. So they can figure the soil loss.
But again, you know, the key too is off-site damage. So you can assess what damage is occurring off-site, especially if you contacted the person who's being damaged and they get permission. Most of, a complaint automatically doesn't trigger an enforcement action. There are some where there is basically no basis in the complaint. And I can think of one that involved a township road. Turns out the contractor shot the grade on the culvert wrong. It was, instead of being following this curve, it was up like this.
Water does not always run uphill.
And in that instance, you know, even on an issue where the complaint is not found with a basis, it can expose another problem that you can at least, especially if you have that township there. And I'm going to pick on that one because I think of that one specifically. They can see what the problem is and then they can fix it.
And we had them where, you know, T is 5 tons right now. Well, they're at 4 tons. But they can still say they're having a problem. Just because there's no basis for complaint doesn't mean you don't encourage them to work with NRCS or other applicable agency and address whatever erosion problems there are, whether it be ag or non-ag. And with non-ag, we might be able to work out a conservation commission thing that we could do some assistance to help them reduce their erosion.
Or head off potential future problems.
Head off future problems. Just because we say there's no basis for complaint doesn't mean it's somebody we don't want to work with. John.
So what's the conservation district's responsibility if you're sidestepped?
What do you mean?
The person doesn't bring the complaint to you?
Oh, takes it to the permitting issuing authority?
Or goes up the ladder further?
What, define what up the ladder further means.
Well, like to a congressman or senator, and then they take it to you
Bill?
guys.
Bill will send it back to you.
We'd send it to the district because we don't have any ability to enforce that part.
Because we've had a couple that, not gone that far, but one may have, but we got it shot now.
Right.
So we've had one that we didn't know anything about it, and all of a sudden we got a call from one of the congressmen saying that he'd gotten a call about it. We knew nothing about it.
And
We finally dissolved it. It took 2 years to get it done.
But the congressman did the right thing. He referred it back, she referred it back to the person with the enforcement authority.
And that's when the process would start here, because then you receive the complaint.
Yeah, that starts you on the 2 months.
That's
right
what I
there.
was wondering, because if you don't hear about it for 3 to 6 months after the initial complaint, I mean, you're really gonna get involved.
Right, this is 2 months after you receive the complaint. Go ahead.
And this is just the example of the form, which is here before you.
We know there is no such thing as a Rushmore County, but it was a convenient name.
But keep in mind, and you can do your own form, but keep in mind, if you look, this is a pretty simple form. It's got some of the basic information, you know, description of the damage and the location. So it gives the board basically a target to look at.
Yep.
So
You may, even though, because this is where the damage is coming, we may find that the damage is much bigger where it's coming from than where, you know, this is being damaged, but the source of it may become bigger than just the one person they complain against.
And then here's basically, again, this is an example of form in there regarding the response, the feedback the district gives to the complainant. And again, you can have your own form, but this covers kind of the key information. And one thing that we did do is we created one form for erosion sedimentation issues and blowing dust. We'll cover blowing dust a little bit. So basically, it eliminates the number of forms you need to do to provide feedback to the person who made the complaint. And making sure you provide that feedback to the person is vital, because you don't want them to think that their complaint fell on deaf ears, whether it's been found or unfounded. And in cases where it's not been found to be a problem, that's probably where you probably spend more of your time explaining to the complainant why it's not found. And some of them may accept it, but in the case of a neighborhood feud, they may not. But that's where your documentation is going to be valuable, because you can show them your documentation, show them why it's not a violation, and at least address some of those concerns. Again, it might not satisfy everybody, but
Very seldom do we satisfy everybody. But this form was, when we created it the first time, it did meet the blessings of the legal people. So, I mean, you don't have to go back to your state's attorney and ask him to create you a new form. This one has been vetted.
it's pretty basic.
It is basic, but it's been vetted. And this is just an example of a letter that you would then send, official letter, remember, gotta follow the steps, make sure everybody's officially notified, and written documentation is by far better than verbal.
And keep in mind, this letter itself is not tailored to blowing dust. That's a whole different
This one, yes,
Deal.
this is not like, this is just on erosion and
sedimentation.
sedimentation.
And again, it's in that package, so you can read it at your leisure. But then this talks a little more about the plan,
If
the
the
steps.
complaint is valid.
Valid, yep. So basically, again, we have some timetables on there. If it's valid, the landowner can either develop a soil erosion and sediment control plan, or then, and we can cover the steps if they do versus the steps that they don't. But again, this is a longer part of one flow chart. Basically, they have 6 months to develop a plan and 6 months to implement a plan. But if they don't develop the plan, then, or they don't develop or implement the plan, it kicks it into a different set, which ends in the same place. If they don't develop or implement, they're going to end up, the district or permit issuing agency can seek an injunction in circuit court. And then, as Angela mentioned before, that's when they're denied assistance by any state agencies or state political subdivisions. Why does it not say federal on there? Because of the Constitution and, you know, we have to
The state
play.
can't tell the feds what to do.
We have to play in our lane. So since this is a state law, we can only deny state benefits.
And it's only financial assistance for conservation. We can't take away food stamps, we can't take away heating assistance. It's only for conservation. They could be denied assistance for programs under GM&P, under school and public lands, under Department of Ag and Natural Resources. Those are the three basic conservation. Although the living snow fence is under DOT, they can be denied benefit for it too.
Although we're still working out the details of funding. So
I'd
that's,
love to have a living snow fence program, but let's not go there right now. Does this make sense? You would take it, your state's attorney is going to get involved at this point, because remember, who is the legal counsel for the conservation districts? State's attorney when it comes to carrying out your legal activities. Who's your legal counsel on your enterprise activities? Whatever lawyer you can get to do it, because you're going to pay for that one. Okay? But when you're carrying out your official activities, the legal counsel is the state's attorney. And you're going to be wanting to talk to him or her at that point.
and I can tell you there's a number of state's attorneys that aren't even aware of this. So it's important to engage them early and often in this process.
Right.
And I've gotten a few calls from a few state's attorneys asking me questions about this and refer to the statute, so.
And if you have a trouble with your state's attorney, let us know, because we will have the Attorney General's office call him. Had to do that a couple times. Okay.
Now, blowing dust, and this keep in mind, this process for blowing dust, the timetables are a lot more accelerated because we're dealing with things that are basically a public nuisance.
In emergency.
Yeah. And also, you're usually dealing with situations that are very immediate nature, like wind, I'll pick on wind, you know.
Do you recall a few years ago that there was blowing dust so bad on Highway 34, that goes to Miller's?
14.
Highway 14, that there was car accidents up there?
Yeah, and that same weekend on Highway 80 down in Nebraska, they actually had a fatality on the highway.
36-car pile. Okay, we've had those before. I will tell you, there has been one time in the state, since this was adopted, that this law was actually enforced and went through the whole process, and yes, it's my county. I can tell you the stories about that one. In fact, I will tell you the story. I live in Presho, and the highway from Presho down to Winter is Highway 183. If you're from western South Dakota, you know that dust blows, right? We got that shale, clay soil that is friable, is that the right word for it? And if you plow it black, it's going to stay where it started.
And the finer you get it, the more static charge it is, the more it becomes repulsive, the finer it gets, blows around. And
We were in 1988, 89, I think it was when it happened anyway, but it was drought years too. And we had a gentleman, out of state landowner, that thing had been black all year long. And so it started blowing, and it wasn't the 100-mile-an-hour winds we had recently. It was the 40, 50-mile-an-hour winds. But it started blowing pretty good on there. You couldn't literally see to drive. You didn't know where the highway was. That's how black and how hard, how much dust there was blowing at that point. That was for about a mile stretch of it. And there was an accident. It was a semi, and it ended up rolling over, and I think it hit another car before that. So we got a complaint. Actually, I think it was DOT that filed the complaint to start with. And
Which means, it goes to show you anybody can file a complaint.
yeah. So anyway, Conservation District got the notice, and it is a written notice, and we had to have a sign and notice. And I wasn't working for the Conservation District then. I can't remember, I might have been on the board. Anyway, but we got the one that was blowing as a result of blowing snow. You gotta call an emergency meeting of the board, you gotta go out and investigate. It wasn't hard to investigate, the ditches were almost full. But we did the on-site investigation, we found it was blowing soil. So we moved on to the second step after that. That's when we then have to involve the county commissioners. Because we determine that treatment is needed, and we issue an order to the owner and operator telling them specifically what we need them to do to stop the blowing dust. At that point, that's when we did ripping. Anybody remember ripping? We had them ripping because we really didn't know what else to do. It was just a big, wide open field. They were farming sections of land at a time. So you can guess how much open soil there was. So we told them they had to do ripping, and they needed to start it immediately, and it needed to be done within 3 days. Part of this is you need to work working with the county commissioners, then going to them and talking to them about it. Because if they don't do it within those 3 days, we have determined an emergency exists. We talk to the county commissioners. The county commissioners are the only ones that have the authority to require the landowner and operator to do the treatment that we prescribed. And if they still don't do the treatment as prescribed, then it's the job of the Conservation District to go out there. You don't have to worry about trespassing at this point. You've got an order. The order goes out, the Conservation District does what we need to. And we actually had to do that. The landowner was in Chicago, and he was pretty much telling us. So we went out and we ripped it. And we notified the county commissioners that it was done, send them a bill. At that time, the law said we cannot charge more than $15 an acre.
And this is where Coddington
Came in.
came in with the 27.
So we did what we needed to. We really did it to about 3 acres, right along the highway, trying to rip it to slow it down. And we gave the bill to the county commissioners, and they put it on the property, and then paid the Conservation District when the taxes were paid. This is where the Coddington County Commissioners were paying attention. They reviewed the law, and they said, you know what? $15 an acre doesn't even pay for us to pull the tractor out of the garage in order to do this type of treatment. So a couple of years ago, we went back to the state and said, this law is $50 an acre, is like 30 years old almost. We need to update that. So we went to what was a current price, and this now has a
Cost of living
cost of
increase.
living increase to it, so we don't have to go back to the legislature each year. The Conservation Commission can adjust that number just based on the cost of living so that we can continue to update it.
Now, true or false? You got a blowing dust complaint, you've gone through this, you're done, right? Probably wrong. Probably, you are correct, probably correct there. Anyway, basically all this does is addresses the emergency situation.
Yep.
To long-term fix the problem, you'd be going back through the process that was outlined in the erosion standards and implementation that we talked about earlier. So this is an emergency thing just to fix this emergency instance, but you still have to go back and address it so it doesn't happen again.
Could we have the same emergency more than once on the same deal in the same year? We can. Given what I told you about this producer and what we have, do you think he's violating the federal farm bill rules? The erosion compliance. Remember, the entire county in Lyman County, and most of West River is highly erodible. Oh yeah, he was, I think we had him at 15.2 tons per acre that was eroding. That violates every standard I can think of.
I have a question.
Go ahead.
You mentioned in here, okay, board determines it's an emergency, or you know, whoever determines it's an emergency, you call your board, contact the county commissioners, okay, emergency meeting. All right, now does that, you have to advertise 24 hours in advance in order
Even for an
to?
emergency?
There's no clause in there that says that waives that provision.
Okay.
Okay, well, that was one question.
Well, we've talked about that though, about if their compressor goes out and stuff, they're gonna mess it up.
Yeah, but that's a little different deal.
How is that any more different than emergency here?
Because the wind could stop blowing tomorrow.
So if the compressor goes out,
The compressor's a little bit different deal, because you got trees that are gonna be dying.
but usually that's not like the board process, you just.
No, you're just going out and buying a new compressor.
Yeah.
Well, they were talking about having emergency meetings, the board would approve buying the compressor.
Oh, we don't
Okay.
have clauses on that. Well, and then there again, not going out on an on-site field visit if you receive a complaint. Can you have more than two? You can only have two.
You could note it on your public notice that you would have a quorum present.
But you could do the,
Two.
you could go and do the investigation with two immediately.
Right.
But no more than two, but you could take a county commissioner or a township supervisor, the highway control
Right,
with
right.
you. But no more than two, because your quorum is three. But you can immediately post a notice for a meeting, so that you can pull the thing forward. So, but yeah, if this is happening once in that area, what's the likelihood it's gonna happen again, whether or not you got through this process?
Almost certain.
Yeah, because the ones on Highway 14 there by Miller, that was about once a week that they were having a problem
And
with
the
it.
interesting thing, that involved non-highway roadable way.
Well, yeah, because it's in Miller, but it was still blowing,
Yep.
it was still causing damage. And the state went back and made them, okay, I'll give you one here. Anybody know what Gunsmoke Farms is? Gunsmoke Farms is the organic farm that was purchased west of Fort Pierre on Highway 34. Made the national news twice for filling the road ditches and blowing so bad and causing all kinds of weed damages, and General Mills is involved in it, by the way. That probably could have qualified as an emergency under this and got the blowing dust act out. The funny thing is, the state made the people of it clean out the road ditches. Do you know what they did? They cleaned out the road ditch, put all the mud in the dump truck, all the dirt in the dump trucks, and they reapplied it to the land using a manure spreader. How long do you think that soil's really truly going to stay put with the manure spreader? Anybody here ever think about applying soil with manure spreader? Anyway, yeah, it's not an example of what an organic farm should look like. Okay. This was the rules we just put it, yeah, we put it into, yeah.
Yeah, this basically involves agreements with other agencies as far as dealing with the preventing soil erosion by wind.
Then the bottom one is, as we were talking to the legislature about erosion control in the last few years, they said, well, how many complaints have you had? Well, there was never any central gathering point for what complaints had come in. Like Joan said, she's had several. She never had to report those to anybody. We had no idea how many were. We guessed it was because usually a district would call us if there was an issue. Either Bill or me or Bill's predecessors. So now this is part of your annual report.
It's on that template that we sent out to everybody prior to the area meeting, so.
Of which only a half of them responded.
They'll be getting follow-up letters.
And then phone calls. So this is on there. You just have to put there at the end, bottom of your annual report, yes, Jim.
You said this annual report is a fairly new thing?
No, we've always had an annual report, but we changed the format of it.
Yeah, we added it to the template.
Okay.
So we can hit everybody for all the information at once. Right.
And the reason we created a template is so we could get the same information from everybody to create a statewide report.
But we do have some districts that,
Refuse to follow it.
well, or don't fill out the entire information, so.
Yeah, we've got several that need work. But anyway, so, but remember, that's in there though, so, because we are told now to report to the legislature what this number is. How many of you did it this year? Name. Okay.
Stuff, with little sediment in. Same way?
Yep.
Same way, so like.
Say you got a
just for
subdivision
example,
of.
Like gravel pits,
Yep,
uh,
well, gravel pits have their own law.
okay, they got their own law.
Yep.
What about like, would gravel roads fall underneath something like this? I mean,
Well, the key thing is you have to show damage at that point.
okay, okay.
That's a key thing.
Say you were, is that west? Okay, sort of, kind of. There was a couple new subdivisions out there,
Right,
okay? And I'm assuming that there's usually done under a development,
okay.
right? And that developer came in and I actually saw one do this. They wanted to level the ground so they scraped all the topsoil up
Right.
and just put it in big piles.
Yep.
Anybody know what big piles of topsoil does?
I do, that was what was going into my
It
yard.
doesn't stay put, does it? So the neighbors say that was on, and they keep expanding west, while the ones to the east are now being buried. The ones to the east can file a complaint against that.
Which,
But your planning and zoning board would never let them do that, right?
we would listen to it.
Okay, so.
Which is what happened in my case. I went to Pierce and they dealt with it.
But let's just go back to that. So how does like NRCS get involved in something like that? Because
You're gonna help us figure out this erosion.
even in
Equations, if you can.
Town and not anything that we wouldn't really be typically involved with?
No, but you also have an agreement with the Conservation District to provide us technical assistance.
Okay,
And that's all we're asking for, is for you to help us figure out WQE, is that it?
right.
And Russell, would you still use Russell?
Right.
And WEQ, not
My
WEQ.
bigger question would be with the non-ag stuff.
Yep.
Most of our engineers are ag related, so
Right.
we're dealing with like grass waterways, those type of things. You get into stuff like this. As a conservation district, would they have the authority to go out and hire a private engineering firm? And then who would pay for that and how would that go?
That's the key, we wouldn't have the authority, you can have the authority to hire anybody you need, but how you pay for it would be up to the Conservation District.
The individual conservation districts, if the state doesn't have something that they could help a conservation district out.
No, you don't want, well, you got a bunch of engineers right now under you, but they're mostly dealing with wastewater and stormwater
Yeah.
with the merger.
Well, and I'll give you an example. In the municipality in Pierre, the city engineer
Okay,
was the one who came up with some remedies
I see.
for them. Because we were dealing with blowing dust.
Right.
They had to wet their piles down. They also had to not, they couldn't have them over a certain height.
Sure.
And they were also supposed to change the orientation of those piles.
Sure.
They also made them put some silt fence down in case we got a heavy rainfall event to keep it from going off-site onto the neighboring property. So at least in the city of Pierre case that I was directly involved with, it was the city engineer who came up with some remediation measures. NRCS wasn't involved.
That's what I was getting at. So
Yeah.
it's not always NRCS
Right.
that.
But if you can help us figure the loss and all that
Right,
stuff.
right.
As far as remediation stuff, don't forget, we also have the wetlands programs. And say that development out there surrounding a wetland,
Right.
we're gonna also be talking to the Fish and Wildlife Service, as well as you guys, because of wetlands issues. Because if that soil is all filling the wetland, just ask the city of Aberdeen what happens when you fill a wetland.
Well, and also potentially the Corps of Engineers, depending
Yep.
on what the classification is of the body of the water in question.
And remember, cities and counties, they still have to follow the waters of the US.
And
That isn't just an ag law.
it also might involve some of our surface water quality people too,
Yep.
depending on what this particular situation is.
Most of the stuff in town is recorded. It's recorded wetland stuff. It's
Yep.
not
Yeah.
typically U.S. Fish and Wildlife.
Unless it's got endangered species attached.
Well, yeah, there's always that, yeah.
Or it's a-
Because remember, you guys got that thing called the Topeka Shiner.
Right, right.
So, but anyway, here's the notification form.
I have one more.
Go.
question. Okay, the Pierce scenario up in Pierre, how they went out and they did all that stuff. They moved files and they looked all, what if they said no?
At that point, then we would have probably ended up in court.
Okay.
Well, that's not, the zoning and planning commission could issue an order,
Yeah, but
because they're under development.
but in that particular instance, had they not,
Right. If
there was damages involved. So,
So you would have had to have filed something against them?
if they had not, because of the damages being incurred, if they deemed it wasn't a problem, but there were damages, then I would still have the civil remedy, which we talked about earlier in the presentation.
And even if the city said, yes, this is what you gotta do, and they did it, but you still have damages, you can still file the civil lawsuit.
Good example point, one of the neighbors had a pile of snert, it melted, ran all over their hardwood floor. They were gone at Christmas time, came back to some nice dry bud.
That doesn't sound like fun at all.
No, that was a winner.
So I would imagine the city could threaten to pull their permit, like their development permit, that we can't have all those.
Potentially, yes.
And then if you go back to the Eggman one where it says they're gonna charge $37 an acre to go out there and rip it, and like they can do that once a week or once every time it blows, it's like for somebody that's in Chicago, like that's curious case was, okay, so it costs them $300. Went out there and did it 3 times. It's like, is that just what it is, and there's no more to it? I know that sounds crude, but you did it for 3 acres over 5 quarters. So,
We could keep on doing, we want to try to work it, if they have to do a conservation plan, but we would also try to involve NRCS, because we, like I said, we found it was like 15.2 tons per acre. Well, the T is 5.
yeah.
Even at 2 times T for HEL, we were way past that. So that guy's out of compliance. And he's starting to give up crop insurance payments, he's starting to give up commodity
That's where the
payments.
teeth comes, is right there.
Money always seems to have teeth attached.
So somebody had to come out and say it's 15 ton an acre is what they're losing.
Yep.
And because he didn't go out and do anything about it, then he's not gonna get his crop insurance subsidy.
He'll go through the process, he can appeal, but he's probably gonna lose at 15 tons.
Okay, so
Right.
so that happens for 6 months.
Yep.
He comes back in May and is planted into something else, then there's not an issue anymore.
Right.
Does everything get forgotten?
I don't know, do you guys ever forget that somebody's out of compliance?
That type of pay job.
Yeah, that's
Once they're out there, they're really not a plans to come back from the farm program. Now, this erosion thing, if we come up with a conservation plan, working with the conservation district, and the landowner did not want to follow that, that's when what they're saying is they could, the state's attorney, start enforcing this stuff. So then all of a sudden he's out there planting grass, or the conservation district might go up there and plant grass, might plant trees, and that all gets onto the, that's what I'm assuming would happen.
Yeah, so does that cost go back to the landowner?
We can't actually put those practices on.
You can't.
No,
okay.
we can get a court issued injunction telling him he has to do something, and it's up to the court to enforce that.
So then you gotta hire a contractor, is that,
He would, yes, if that's what he wanted to do.
or do it himself?
Yeah, or do it himself.
But the conservation district couldn't go up there.
The only time we do it is when it's an emergency.
Okay,
With the order issued by the county commissioners, because the county has to agree to it too.
okay.
For blowing dust only.
For blowing dust
Okay.
only.
And that's where the confusion lies. We've gotten those questions on non-blowing dust
Yeah.
about that. There's no provision in the law, in the injunction.
That just,
You could hire the district.
Good.
you can hire the district to do all kinds of stuff if you wanted to. Put in some buffer grasses along the road to at least put in some trees. He's eligible for, once they're out of compliance, are they eligible for cost share to bring them back into federal compliance?
If they're working with it,
There's always a way in.
there's always kind of a grace period, a good faith period, that doesn't like to say good faith.
Yeah.
They're working towards something.
And they can file the appeals. You know, you guys have dealt with wetland appeals, you know what it's like.
There's always potential violation, there's never an actual violation. That's how all the rights are.
We're always great. Okay. And we need to change that list, I have one. We still have the $15 in here.
Okay.
I need to change my
I was
slide.
gonna say.
I think I need to change my slide, thank you for reminding me about that. Okay. All right. Now we're to highway damage. And this did come about, my county highway superintendent took me on a ride one day through Lima County. And he pointed out that just how much we were spending on the same pieces of land miles of road every year. Okay. On a high, how much, just a quick question for you guys. Think about your property taxes. Who's the biggest recipient of your property taxes? School, very good. And yet, who do you blame first? Poor county commissioners, right?
They give us the money.
School districts are your biggest, unless you're of the county's budget, normally what is the largest expenditure? It's roads and bridges. Maybe not Minnehaha County, but in most counties across South Dakota, the -- 1 expenditure in counties is roads and bridges. Would you buy that? And if you're taking, well, let's just say a $500,000 budget, which is cheap, and you are spending half of that on the same 5 miles of road every year, is that a wise use of your county dollars? On townships, what's their biggest expenditure? Roads. Roads and bridges. Snow removal. You got a township that actually moves snow. But it's roads and bridges again. Their budgets aren't large enough to continually sustain having to fix the same roads over and over and over again. And that's the point my highway superintendent tried to make to me. That we were constantly replacing the same culverts, they were constantly replacing the same gravel because it was getting blown full of dirt, or they were constantly cleaning out those ditches because they were full of wash dirt. So we created this law in somewhere in the 90s, I can't remember exactly when. But it took quite a bit to get through the legislature. We had to make sure that we crossed every T and dotted every I. So what you see here is the highway superintendent, whether it be the county or the townships, maintain records of highway maintenance. And they do now. Most of them do now. If they don't, that'd be a surprise. They can then use those records to compile lists that are consistently affected by severe and persistent erosion. Say they go through there and they find on this half-mile section of road, in 10 years they replaced the culvert 5 times. Would you consider that persistently and severe? Yes, you would.
And I'm guessing when you got this established too, a lot of culverts and ditches washed out in 2019, extraordinary event.
That's why you see the word
Persistent,
consistently.
severe.
Yep, they didn't want to see a one-time event. They wanted to see this example of it's continuing to happen over and over and over again in the same spots. We actually went to places where 30 years ago you could have rode a horse under the bridge, and now you can barely get water through the bridge. I mean, so we got places, every county has these, every township has areas that are affected. Okay, then what happens is the county commission and the township board review the list with the conservation district board. And the district supervisors go out and look at these, and then they're starting to identify, this is where we ask again for NRCS assistance, where's the erosion coming from, and what can be done to correct it. If there's a culvert that's being replaced every 2 to 3 years, what do you suppose the problem is?
Tiling.
Well, that could be part of it. But we're getting soil coming down in the water, aren't we? We're getting water erosion. If the field has been black and plowed twice in the fall and 3 times in the spring, do you see there's going to be an issue? There's nothing to hold the water. So we look at those. Then this is the important part. The county, township, and the conservation district decide jointly by resolution what areas are you going to address. Okay? Make sense so far? This is a cooperative process.
And the reason being is you're dealing with the jurisdictional issue.
As well as the legislature wanting to make sure that we were absolutely sure that this is what's going on. So then the county township board notifies the landowner their erosion's been declared a nuisance. That's what this falls under, is the nuisance loss. Notice has to be delivered in person by the sheriff and filed with the county auditor. That applies whether it's a county or a township. And unless the landowner repairs the damage, so we're not going to replace that culvert this time. It's not going to be the county or the township paying for that culvert. The landowner has to repair the damage. If they don't do it in 30 days, the county will repair the road damage. And then they will assess it against the property.
For a lot more than $37.
For a lot more than $37. So if the landowner does begin to work to correct the damage at the landowner's cost, we have stopped right there. If the landowner fails, again, we go back to the township, they bill the landowner for costs. Okay? The landowner would either pay the bill by November 1st or it gets assessed on its property taxes. Make sense?
And
And
then,
then we encourage them to get a conservation plan.
and in that 30 days, if there's an accident or catastrophe, who's responsible?
That part is not in the law. What do you mean accident or catastrophe?
Well, what if it's a flood and it goes across the road, takes the T-belt, somebody drives through, goes through the water, falls through, wrecks the car, somebody gets killed, who's responsible?
That's a good
That would
question.
be up to the courts to
That would be up
decide.
to the court to decide.
You would have to do a you'd have to do a finding of facts to find out whether you were dealing with extraordinary event or whether there was negligence on whoever's part of it. So
Right.
it would really depend on, John, the circumstances at hand.
You really can't write a law to the place to every situation.
Has this been used?
We started it in Walworth County. We got as far as the notification and then they stopped for some reason.
Now, is this something that, does the county, townships, do they review this at their annual meetings?
We've had the training at some of the highway superintendent meetings. We've never been able to get a presentation to the county.
Interesting.
Which is why we encouraged you to bring your township and highway counties. And if you want us to come out and visit with your group of superintendents, we're happy to do that. The idea is to get you guys to all understand these are the laws.
You know, back to John,
Yeah.
mentioning that too, you know, I still have a problem now with this, you know, we call this emergency meeting. In a situation like that where there's a, you know, you can't see the road and people are dying because of it. You know, there should be some exemptions or.
And I can check with the Attorney General's office on that, because we've had a couple of different people on that.
You know, let's say it happens at 1 o'clock in the afternoon one day.
And you know the wind's supposed to blow for 3 days in a row.
And by the time you hear about it, well, now you put stuff together, your notice for your 24-hour meeting, and now you won't probably get out there until, you're looking at 3 days probably before you.
But that's where I'll check with the Attorney General's office on that, because, you know, there's, the way the public notification requirements are, doesn't seem, I don't know what kind of wiggle room there is in there. And not being a lawyer, it's better to talk to a lawyer.
I'm pretty sure if your community had a tornado, they really wouldn't pay much attention to the emergency meeting laws. We'd go forth and conquer it.
But that is a good question, Joan, because maybe if, depending on what the answer is, it might require a legislative fix too.
Possibly. We already got something else we need to fix legislatively. Okay, so center list.
I think so.
Yeah, that's in case we're going to create other formats. So we managed to work our way through the maze of all the lots. What comments, thoughts, questions? What did we miss talking to you about, with you about? Everybody's just ready to go forth and conquer?
It seems like it's really expensive for the conservation districts. You get a complaint, I mean, it could, by the time you do your supervisors and your employees and all that stuff, you're looking at a lot of money that's costing.
I probably don't disagree with you. Do you have a remedy?
No. None, this was complaining.
Okay.
Comment.
Comment.
Well, okay.
Well, the
Complaining.
elected supervisor's
Job.
duty to, you know, do what they need to with it. You're right, we have to pay them per diem, mileage.
Well, they have to take time off their own jobs.
And need your time to.
And not every conservation district goes per diem and level.
Then you go do 3 acres, you know, 500 acres, and you get $37 times 3. It's not even paying the fuel to get there. Yeah.
Well, like I said, I can honestly say out of all
Yeah.
the complaints that we've had in the 35 years I've been there, we probably had maybe a dozen. So really, that's not very many over the course of that time frame. And the ones that we have received have been able to work out. We've always had one where it was, well, it wasn't twice.
Did you verify? Is there something?
Oh, Ryan. Oh, don't know where
Given
it is, that man.
I know it's different.
223 people live there? You could see that in Faith, you could see that in Philip. I mean, it's dry out there. But, I'm sorry, I get off on stories.
One of the complaints that we had too was, I mean, it's not always the alleged violator that is causing the problem. The complainant also can have issues with we had to deal with.
Yep.
They live along lake shore line and kind of small lake, so they can run one of those things. And this, what was that field that was causing erosion? How big was it? Yeah, but I mean, yes, there definitely was erosion from that field, you know, and years of farming the same way type of thing that it was building up along the fence line, but also the complainant, I mean, for mowing the grass that was around it, they were mowing it as short as they could because they wanted to move that water as fast as it could so it wouldn't cut. Well, we went down to his shoreline and his little boathouse there that was just, you see how high the water level had been up on it. But there were big gullies going down there, so they weren't helping the situation there. So in the letters that we sent, you know, we also recommended some things that he could do also. Did he do it? I have no end of sound of land. Son and nephew.
So the son and nephew's doing thing then?
They actually did, yeah.
Okay.
That's the one where the alleged violator, the passed away, so we ended up, and it was kind of the second time around. We got together again.
Some of these are gonna be over and over
And
again.
got engineers involved with it. Yeah.
And I'll also-
Put the land into CRP.
There we go. And also point out that the violating land may not be the immediately adjacent land. We had one where the producer came in and was mad at the neighboring landowner, and it was running down a creek. Well, sort of dry creek, you know how creeks around here have water in a part of the time? Anyway, it was the headwaters of the creek that it was actually coming from because it was fairly steep. And they had broken all the grass and they were plowing it uphill, not sideways or no-till. That's where the erosion was coming from. It wasn't coming from the landowner in between, which was pretty flat. So then you have, that's part of that part. You gotta figure out where is the erosion coming from. Because it may not be where the complainant says it's coming from. Because they may not understand the hydraulics or the nature of it. So. Anybody else got something you want to talk about? Ask about? Did we help you at all? Do you find this useful? Yes. Doing it? No, nobody's excited about doing it. We'd like to get the word out as much as possible, though. I know we got most of the upper counties, we need to get the lower counties. But I'm glad you guys came. We're going to get a list of counties that you check them out. Thank you.
And Joe, and I'll check in if you just want to.
Okay.
Yeah,
we got minor.
Shoot.
We got Kings. We got Minnehaha. I'm sorry, was that what you got? We got McCook. We got Kingsbury. We got Turner. Is that everybody? Oh, Lincoln, I'm sorry. Where'd you go?
He snuck out.
Well, then we don't count.
We need to deserve it.
Minor Lake, Kingsbury, Kingsbury, Turner, and Lincoln.
Okay, we'd really like to do at least one of these in each of the areas, and you're now our second one, so we gotta wait till we get to Clay. Clay, Union. The Union's not in ours. St. John is an in ours. So we got a pretty good attendance.